All right. We are ready to get started. This is another meeting of the Family and Juvenile Law Subcommittee for the Judiciary Committee. I am Delegate Charlotte Crutchfield. It is Wednesday and it is March the 12th, and we are going to go ahead and start our meeting. Our first bill is HB 1209. And we had some discussion earlier about 1209, and that is the bill to allow the reporting of children in neglect and abuse cases where there have been fatalities. And I'd like to just start off with just kind of a general question, and that is, I'm not sure if all the committee really understood how it works right now, because you are doing this right now between DHS and the state's attorneys. And I want to make sure how the process currently works, and if you want someone from DHS want to explain it, or state's attorneys. Go ahead. Thank you, Rachel.
Of course. Thank you, Delegate Crutchfield. So we'll go ahead and answer how it currently works. And we have Ramonte Green from our Social Services Administration that he can speak to that. Go ahead, Ramonte.
Yes, good afternoon. So currently, whenever there's a request for records from the department, we have to consult with the state's attorney's office as to if we want to release this information or not. The state's attorney's office then they advise us as to if it will harm the state or not. And then in that moment, we make a determination as to if the information is being released. Jonathan, can you chime in if I'm missing any specific steps on that process?
No, I don't think so right now. Yeah.
Okay. And these are like FOIA. Well, they're not FOIA. They're Maryland information request made by any individual, right?
Yes, ma'am. Any constituent may make the request for records related to a child, or, involving child abuse or neglect. Yes, ma'am.
Okay. And I know there are some guidelines around it right now. So what I wanted to make sure I understood, and maybe the state's attorneys can help out here, what is the difference then that you're asking us to do with this bill, 1209?
So just in general, the only difference is at this current time, the authority through, after consultation with the state attorney's office, rests with the secretary for the Department of Human Services. The change in this current ask is that the power for release of information transfers over to the local directors, who ultimately report up to the secretary. The concern we have with that is that the secretary is the appointing authority for the entire state and all of DHS, whereas if we're directing this to a local director, that director is ultimately at will to make the decision for an entire state, but only pertaining to their jurisdiction. We never want to, as you all know, in respect to authority and a hierarchy, we never want to, overrun or omit the power of the appointing authority. Their responsibility is to ensure the well-being of all kids in the entire state. And while that does rest with local directors as well, he is the appointing and acting authority. And so we don't want to diminish that by passing that over to a local director.
Okay, so are you basically saying, for example, I'm from Montgomery County. If there was a fatality that was in Montgomery County, then it should go to that local Montgomery County director, and
Yes,
they would handle it between them and the state's attorneys. And then, okay, got it. So that it's more localized, and you have some control over the data or understanding it, because maybe the person in the local field office knows a lot more about the situation. And okay, got it.
Absolutely.
Okay, and go ahead. Did the state's attorneys want to comment at all on that? Thank you.
Yes, thank you, Madam Delegate. I can sort of chime in on the State's Attorneys Association's interest in this bill, which is somewhat narrow and significantly, I think, more narrow than DHS's interest. And that is, these cases tend to be of very great importance to our communities. These are cases that are often highly that we have a great deal of people coming to court to watch, and our concern primarily is the premature release of these records while an investigation is, or sort of at the conclusion of an investigation, prior to the determination of whether or not we're going to initiate charges and during the pendency of that case. In other circumstances, if we were to get, as you'd indicated, a Public Information Act request for records related to a pending case, we generally don't disclose those records while the case is pending because we don't want everyone who's accused is entitled to a fair trial, and that includes a jury of their peers, an impartial jury of their peers that doesn't know anything about the case or isn't biased one way or the other on the case. And in high-profile cases like these, it's very difficult to pick a jury anyway, and it's going to be much more difficult if the public generally has access, if the media has access to investigatory findings made by DHS as they are conducting this, as they're conducting their investigation. So we're grateful for the opportunity to work with the sponsors of this legislation to ensure that the bill, as it's moving forward, retains that ability for the state's attorneys to temporarily, not really preclude, but delay the release of this until it's released at a time where it wouldn't prejudice a case as it's moving forward.
Okay. Okay. And I noticed I was looking at page 2, I'm really looking at line 26, 27, and 28. But if you go up to line 10, where it talks about a request disclosure information concerning child abuse or neglect, okay, notwithstanding any of the other provisions of law and subject to paragraphs 2 and 3, the local director of the security or the secretary shall, within 30 days after receiving a request, disclose information concerning a child abuse or neglect. If the child, and then if you go down to 26, line items 26, 27, is the subject of an investigation, a report, referral, or complaint received by a local state department agency, and suffered a fatality. So I think in the former language, it really did indicate that the state's attorneys sort of had the ability to stop anything if it was an investigation. Do you feel like this language is enough to do that for you so that it comes to you guys directly and you can determine, or does it need to be stronger?
I think this language is appropriate. If we turn to page 3, starting on line 6 through 11,
Okay.
That affords us the opportunity to review the information that's proposed to be released by the department. And then we've got sort of redactions provided for in lines 15 and 16 of that same page. Our sort of weighing in on this, when my understanding, the sort of context of this bill is to bring us in line with a federal statute related to the provision of these records. And this, I think, has been, this is maybe the 3rd session in which it's been introduced. So we previously worked with Delegate McComas, and I believe Senator James in JPR has introduced versions of this bill. And on some of the versions as sort of introduced or as drafted did not include that carve out, which is permitted by the federal statute and really important to the State's Attorneys Association, so we can continue to provide individuals who are accused of these types of crimes fair trials within the jurisdiction in which it occurred.
Okay, great. All right, I see a question. Delegate Kaufman, you have a question?
Yes, I do, Madam Chair, if that's all right with you.
Yes, please go ahead.
I have 2 actually, but they'll be brief. My first question, and let me preface this is not my area. I do Medicaid lobbying when I'm not here. So my basic question is, you mentioned media, but who makes these MPIA requests? Is it like WBAL or WRC, where Delegate Chair Crutchfield and I are from, or can it sometimes be a nosy neighbor or somebody else? Who typically makes these requests? And the other question that I had, and while I was waiting to be called on, I skimmed the bill and I didn't see it, so maybe I didn't go down far enough. But how long can a state's attorney delay the MPIA? Because I have a request, I have a concern about the state's attorney just being able to say, add in perpetuity, I'm not releasing it. And I see something about 30 days, but if you could just elaborate.
Those are excellent questions, Delegate Kaufman. The first question, I don't have data regarding sort of the precise who's making these typical requests. I practice in Wicomico County. I'm with the State's Attorney's Office in Wicomico County, and we haven't had a case like this since my tenure in the office. So I can't say specifically for Wycomico County, and I don't have data statewide, but in other contexts where we're dealing with high profile cases, we see public Information Act
bond.
requests
The
from
appropriations?
across the board. We'll receive requests from concerned
I just did
citizens.
that.
We'll receive requests from the media. We'll receive requests from authors who are looking to write books about this. So it really is, particularly cases involving, that receive a great deal of media attention already. We'll get requests from pretty much everyone who's interested in sort of watching body-worn camera footage related to a case or reading an investigatory report. And I would guess that in this context, it would be probably pretty similar to that. The individuals who are looking to learn more information about a case where a child in state custody has suffered a fatality or near fatality would be able to avail themselves both of this provision and of the General Public Information Act provision. And to your second point, and I should have reread this bill in its entirety before the proceeding. I got tapped in sort of about an hour ago, but I believe there is a provision that is once it would no longer jeopardize or prejudice a prosecution, it needs to be released within 10 days. So
Okay,
I think,
to me, that's a little subjective, but I appreciate
So-
it. Keep going.
Yeah.
So
You're
I think
absolutely correct,
if you turn to page 3, and in line, just take a look at line 15 through 18 is, I think, where you're talking about, Mr. Gilbert. It talks about State's Attorney's Office redacts information in accordance with paragraph 3 II of the subsection. A state's attorney shall notify the local director or secretary within 10 days after the conclusion of the related investigation or prosecution. Is that what you're referring to? Okay.
Yes, that's absolutely correct, Madam Chair. Yeah, it looks like so there is, and so that is a more definite sort of event than Delegate Coffin's absolutely right, sort of on the conclusion when it would no longer prejudice an investigation is much more subjective. But this requires notification of the local director.
Okay, well,
or the
I
secretary
thank
within 10
you.
days at the conclusion of an investigation.
I thank you both for your indulgence. I have so many bills swimming in my head at this time of session. Thank you very much.
Thank you. Any other questions about the bill? Sounds like everybody understands it, has no questions. Okay. And again, I think part of this too is that this is tied to the federal statutes, but also is it tied to some funding as well for DHS, if I'm not mistaken?
There is CAPTA funding that is attached to, how we adhere to this. Ramonte or Jonathan, can you speak to how the CAPTA law works a little bit better?
The within CAPTA, it just mandates that any state that's receiving CAPTA funding provide information to constituents who may request the information. That's solely the basis of it. There's nothing more outside of it.
Got it. Okay, and I know that currently, so there's no addition to this, you currently release the name of the alleged abused or neglected child, the date. Let's see, the findings made. Yeah, okay. So those are all things you currently do, so that this bill doesn't change any of that, really. Correct?
So I think the major difference is that current, if I'm remembering this correctly, the current statute, we would provide, the child named in a report of abuse or neglect if they've suffered a fatality or near fatality. The bill would amend that and sort of open that up to is also the subject of an investigation, a report, a referral, or a complaint. So it's, it's sort of broadening the types of categories. I don't know if Ramonte or maybe Patrick, you want to sort of speak to the impact that may or may not have on specifically on cases. I think the ability now for us to sort of press pause and say, that a delay is appropriate because it may jeopardize the case the way that I read the bill on page 3 is that no matter what, we have, the state's attorney's office only has 30 days after receipt of the notice to go ahead and make those redactions. Current statute, if I'm not mistaken, allows the state's attorneys much more time to hold off on making those redactions or to determine whether or not it's appropriate to release those records.
And I think I saw, before we go to Ramonte, I think I saw Jonathan Moore. Did you have a comment?
It was along the lines, thank you, Delegate Crutchfield. It was along the lines of what Rachel was saying.
Okay.
So the CAPTA requires that we have provisions to release this information when abuse or neglect has resulted in a child fatality. And so, like Rachel said, this changes it a little bit to be that if it's in information that is subject of a report, an investigation, a referral, or a complaint. So it does change. It does broaden the scope of what could be released, and that would mean, as the way that I'm reading it, it would mean that I think that even if a referral did not include an allegation of maltreatment, for example, if there was a homicide and we had a screened out referral because no maltreatment was reported. If both the alleged maltreater and the alleged victim were youths or something like that, and it wasn't a child maltreatment case, it seems to me that those reports could be subject to these kinds of requests because they wouldn't have been before because they didn't include an allegation of maltreatment.
Okay. Okay, yeah, and I do see on page 2, section or lines 24, I think, through 31 kind of describe the one. I think the major thing is that the child was in the custody of local or state department of agency and is the subject of investigation report referral. Okay.
That is correct, yes.
Okay, got it. Okay. All right, does the committee have any further questions? Okay, I don't see any. Well, thank you very much for being here. The folks from DHS and also the state's attorney's offices. And I know DHS will be on another bill coming up shortly. So do I have a motion on this bill? A favorable?
Move favorable, Madam Chair.
Okay, and do I have a second?
Second.
All right. And I think we're ready for a vote then. And I'm going to just do a roll call vote real quick here. Delegate Bartlett. If she can get herself
Yes.
unmuted. Great. Delegate Boucher. Is he still here?
Delegate Boucher.
He had to run and test.
Okay. All right. Delegate Kaufman.
Yes.
Okay. Delegate Pastor.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Simmons.
Yes.
Delegate Simpson.
Yes.
Delegate Stinnett.
Yes.
Delegate Taylor.
Yes.
Delegate Tomlinson.
Yes.
And Delegate Valentine.
Yes.
Okay, great. All right, so that one is passed out of the committee. All right, we're on to HB 110. And again, thanks to the state's attorneys for being here. I think we have a few people from DHS that'll be on. Okay, let's see. All right, I see them here. All right, so we had a discussion a while ago about HB 110. And I wanted to just kind of bring us back around and also think about a few things here. So HB 110, and I know Delegate Simpson and Taylor are here and they can certainly chime in, but I think the problem that HB 110 was attempting to resolve was a problem with a large amount of errors and other issues within the DHS system in determining who was non-compliant with child support, because those folks would then have their information sent over to MVA for an automatic suspension. And then after that, of course, after trying to do further investigation, they possibly would be sent to for a contempt hearing. And HB 110 was attempting to put some due process around that so that there will be notice to people along the way with the various steps that they were taking as far as when their license was suspended and what steps next the individual had to make. Did I kind of explain it correctly, Delegate Simpson?
Yes, you did.
Okay, Delegate Taylor, you okay with that? All right. So what we had was we had a lot of discussion around this. We heard from DHS, we heard from the bill sponsors, and I think I want to kind of wrap it back around, and I want us to think about a way to possibly get to the real concern here. And I think that the way we can think about that is to really look at, again, what the issue is. And the issue is that there's this error going on. One of the things I know that DHS had agreed to, and I'm just gonna, again, just confirm that, is that you all had agreed that during that initial phase, that investigation phase, that you're willing to take that out to 120 days. So in other words, it's not the initial 30 days. After 30 days, right now, what happens is then the person's information is sent to MVA for suspension. But what you're willing to do is to do a little bit more time around that to really investigate the situation and confirm the non-compliance of child support. So I want to make sure that that's kind of what we had all agreed that was good. Okay. So now with that in mind, one of the thoughts that I would like for us to think about is whether we can now take that and say to, and what we can do next is really think about the non-compliant people and confirming non-compliance, okay? And only sending, because I don't believe there's anywhere in the statute where it really says the only people that should receive a MVA suspension are only people that are non-compliant. I don't think it says that anywhere. And I don't think there's factors that say what it is you should be looking for to confirm non-compliance. And so that's what I'd like for us to think about a little bit more. And what I propose is an amendment that basically says, that DHS, when DHS is, once they have completed the investigation process, which would include looking at numerous factors, such as whether the obligor is under, has Social Security benefits, or whether the child actually lives with them, but there'll be several factors, which would be pretty much the factors that are currently in the bill. So if you go down to, and if you have the bill in front of you on page 4, HB 110, page 4, starting with line 22, it talks about the times and the information that we should really be looking for to confirm that a person is non-compliant. And under the bill, it currently talks about the court doing this. But what I'd like to do is to propose that DHS do this in the investigation stage, okay? So that we know if the minor child is residing with the primarily with the obligor, then their license should not be suspended, has documented disability, et cetera, et cetera. So there's a list of things. And so I want to give you guys, DHS, a little bit of time to take a look at that, but that's what I would propose as a concept. So in other words, you are sending the file of non-compliant people or obligors, but you are confirming that these are the people whose licenses should actually be suspended. Because again, the problem is the amount of error, et cetera. And I know that you guys have also put some fixes in the system. So again, we should really just be sending those people who actually are non-compliant. So I don't know if you have a comment yet. I know you have to digest this a little bit, But that's kind of my thought around that. And does the committee have any questions about that? Yes, go ahead, Delegate Valentine.
Thank you, Madam Chair.
Mhm.
Would the department initiate that type of an investigation after the 120 days is passed? Is that when that would kick in, or what would be the time frame?
So it's during the 120 days. So
Okay.
in other words, once they get notice, that there is an arrearage situation, then they should begin and this is kind of using their terminology, investigation. They start to look at where the issues are with that individual. Why haven't they been paying? They send notices out. They do everything they can to reach out and to contact the person. But they also have indicated they have some fixes in their system where hopefully they won't have to repeat some things. Because right now what happens too is they end up, for example, having reoccurring suspensions, but the person has paid, but it hasn't caught up, but they're fixing those kinds of things. Anybody else have any other questions? DHS, would you guys like to respond? I know, I'm catching you off guard. Sorry.
Well, thank you, Madam Chairwoman. I do appreciate the ability to kind of, think openly and kind of conceptualize how this may look, and really trying to bring us all together to a place where we're all happy with. And I do agree with the non-compliance piece. When we meet that 120-day out of compliance, non-compliance threshold, that trigger, that is certainly doable. I also think it's doable to have an additional time, maybe notice, or maybe email, or maybe something to try to elicit this information during that 120 days. I don't think that's too big of a burden to bear, and another one of those pieces to try to help reach out. And certainly with our messaging, with our community partners, again, getting that engagement. I do worry because it does, again, we'll do our best to try to have that information, but it does somewhat depend on them reporting that information to us. And so I do hope that maybe, by the way we message, how we message, who we message with, we can hopefully change that perception of coming and talking to child support, so that we can get this kind of information, to your point, to stop suspensions that shouldn't occur. And again, not just that one notice or the delinquency notices, have something that looks different, that feels different, that is a different way to get that information. Conceptually, I'm excited by that idea, and we do try to do those things that are outlined in the bill. I think maybe the one thing we don't track right now is, the current residence of the child. If they still owe arrears, they're responsible for those. But to somehow, I think we can somehow in the system track that, so that we know if the child's with them now.
Yes.
That's a piece we remove. That's something that's off the table.
Okay. And also recognize that we're not going to have the due process piece. This is all we're going to do right now. Okay. Is to really just kind of make sure that the right people are going to MVA. All right. So whatever you do in the back end, you guys can continue to do, but we want to make sure the front end is correct. Okay. And that's what this will be doing.
Delegate Crutchfield, we will still have a due process to ensure that they have a clear understanding on what the next steps are with our results of the investigation, with and providing other options. But I would like to take this back. Jarnis was not able to be on the call, but I just echo Jenna's sentiments on being open. And I think that's something that we can definitely operationalize and simplify the information we need to get from the non-custodial parent, so we can make a well-informed decision. So thank you, Delegate Crutchfield.
Okay, thank you. Thank you. Does the subcommittee have any other questions or concerns? Okay, yes, Delegate Taylor, please.
Thank you, Madam Chair, and thank you for these suggestions. In my head, I'm trying to walk through the whole process. So just help me, you guys, what happens if, we're at the 110th day, and we still haven't verified, like we still don't have the information that you really need to make the decision as to whether or not to send their name to MVA or not. So let's talk about that. Like, what would you do? Are we going to send it anyway because we're going to assume that they're non-compliant because they're not working with us? Or are we going to assume on the end that, maybe we should just work a little harder to make sure we get the information, or we haven't been able to contact the non-custodial parent? Like, just concerned that at the end of 120 days, that potentially there may be still some questions unanswered, and we may still be in a non-compliant status. So can we just talk through that? Like, what are your guys' thoughts on what you might do?
So you may want to start with what you currently do. Okay, so when you get to your 30 days right now, and you have not been able to reach them, et cetera, what do you guys do? You just send their name, right, to the MVA, but I'll let you go ahead. Sorry.
And Jenna, again, just make sure I'm not transposing the things. It's not after 30 days. If you're 30 days non-compliant, they just still receive a notification from the Department of Human Services stating that they have missed a child support payment. It is 2 times the support obligation amount. So scenario 1, if I have $100 I'm supposed to pay on my child support, and I missed the full $100 on 30 days on month 1 and a full 100 days on month 2, that's when the referral goes out. In addition to that, that's when it pops up on the workers' work item, and they send out an administrative hearing notice, meaning they're asking them, please come into the office so we can discuss your child support matter. The second scenario is, remember, after 30 days, they receive a notice. 60 days, remember, it's 2 times the support order amount. They could still be making partial payments and they will never get referred. It has to be 2 times their child support amount. So when that threshold happens, because that could be 90 days or 120 days, we triggered that administrative hearing notice. We contact the non-custodial parent. We call them on the phone. We ask the custodial parent, do you know his last known address? Do you know if he's working? Do you know where he is residing? To try to engage into the non-custodial parent before that referral is triggered. So that's our current process. To your question, Delegate Taylor, if on that 110th day, and we have sent notices, we have sent administrative hearing notice to come to our office or our court hub, depending on the jurisdiction. We have called, we have texted, and we have communicated to that custodial parent. It is documented in the system, and they will end up being referred, because we can only base it on what we have done our due diligence research. So we look into our federal parent locator. We have a locate tool that is required by the federal government for us to look into the system to see if there's new data. We look to see if we have anything in our quarterly wage to see where the non-custodial party resides. We send out a letter to their last employer and say, hey, we know that he used to, or she or them used to work there. Can you please give us their last known address so we can update our records so we can send them a notice? And after all of those efforts, it does go and become referred to MVA, selected, then referred. They get the notice from MVA. And if we still don't receive any information via phone, email, work order, or mail, because that's typically, right, the 4 things: work order, email, phone, letter, or in the office, the administrative proceedings will continue.
And just to add to that with Samantha, the reason we continue is because we default to the last time they had to prove to a court their ability to pay, right? Which will be whenever that court order was entered, which is at that, 120 days ago or 60 days ago. After, to Samantha's point, after all those efforts, if nothing else comes of it, we default to, hey, the court found them able to pay this amount. This is what the court ordered. So that's why we proceed.
Well, thank you for that. And that sounds like a lot of work, but it doesn't sound like it's any more than you do now.
Correct?
So that is what we do now.
Correct.
Mm-hmm.
Now, what Delegate Crutchfield is proposing, which, look,
Okay.
I'm feeling the warm and fuzzy, okay, is we would like to take the time to talk to the executive director to say, because in my mind, I'm like, what can we do, like an intake form, just like you are requesting in the bill, to say, I'm now reaching out to you in a document to say, because sometimes non-custodial parties are not aware that now I have the kid. There's some other things that they should be doing to ensure that they can preserve that right, as now that they're the custodial parent. So we'll say, hey, do you have custody of your kid? If so, what's the frequency? We can go into those steps, kind of similar when we interview them, when we're right sizing their order. We can mimic the same process. So then we can provide them resources up front to say, oh, now you have the kid. We're going to tell you what you need to do to obtain custody of the kid. So now we can judicially get an order. So now we can adjust the accounts and deal with the child support at this stage. So that's what I'm thinking where we can do. I just want to confirm that to see if that is if it's going to be, I'm below the big boss. So, but I like, what we can do to add a layer of additional engagement.
Right.
Yeah.
So that it doesn't feel like we're just determining based on the information that we have back in 2005, because that's sometimes that happens. And it's like 10 years later, they don't talk to us until there is a change and they're not communicating with us. We can kind of be proactive to get that information, like right sizing in order. I hope that does.
Thank you. Delegate Simpson, you had a question?
Yeah, I just want to be clear in your example that you gave to Delegate Taylor. Are you using this mechanism to find individuals? It seemed to be that they were paying their support, but they had accumulated more arrearage than was allowed. And so there's 2 things I have a question. One, it seemed like in your example, you indicated that you were receiving payments from them, but that their arrearage now went above a certain level, even though they're paying. And then the other piece that stuck out that I wrote down was, it sounded like you were using this process to encourage people to reach out to you, but it seems like if you're going through that and you now have suspended their license, but they don't know that, it almost sounds like the only way they would know that is if they were pulled over and then informed they were suspended. So you're using this as a tool to encourage them to contact you?
Okay, I'm going to try to. So the first question, Delegate Simpson, with regards to my 2 scenarios. Non-compliance means is 2 times the amount of your child support order. So 2 scenarios typically happen in child support. I did not pay my full SOA more than 2 consecutive months, like no payments, nothing, 0. It will be referred, selected and referred, but they received all of these notices from DHS from their last known address. The second scenario is my child support order is $100. I made a payment. It's just not the full payment. So month 1, I only paid $50. It's not going to refer them because it's not 2 times their child support order, because now it's $150. It is when it becomes 2 times that now it is selected and referred. So scenario 1, they are selected and referred sooner. Scenario number 2, it could extend the time because it's not meeting that threshold criteria. So in terms of the federal driver's license program, unfortunately, it is an indicator because we already sent notices on DHS or jurisdiction's letterhead to say, hey, you do have a payment due. We need you to contact our office. Here is past due. We need you to contact our office. If there's other information you need to provide us, please contact us. So they receive this letter every single month in notices. Then the notice change when it gets to that point where they're going to be selected depending on the non-payment, depending on where that non-payment threshold is received. Now, you get a letter from the NVA, which is a different letterhead, a different form, a different texture. Maybe you were ignoring those letters from DHS and you see another letter with a different form. You may pay attention to that more. Just like my BGE bill. I'm not saying I don't pay that bill till that pink card comes in, but I do. But you see the letter go from white to blue to pink. It's more important for me to look at that pink card versus that white card because I know somebody's going to come in front of my house and turn off my water. So I'm saying that to say, yes, unfortunately, we have to use that tool to say, hey, you have to come to us because I don't have updated information.
Okay, yes or no? If I owe $100,
yes,
and you're saying that if at the point in which I owe $200 in arrearage, I could lose my license even if I'm paying?
No.
200 in new arrearage. So if you're paying like $95 a month, it'll take 20 months for you to reach that threshold of new arrearage from that $5 that's like rolling over kind of that less than amount. So if you're paying $50 of your $100, it'll take 4 months. If you're paying nothing of that $100, it'll take 2 months. If you're, paying 70. So
I mean, I think folks are feeling that
hold on, but during that time, you're sending notices, right? To say
yes,
there is the arrearage.
And it gives you the balance, it gives you the payment.
Right.
They have a breakdown and they also have the tools in their portal to pull up their payment records.
Right.
And when we send out a wage withholding, a copy goes to the employer and a copy comes to them. So if they dispute it, they can go through the investigation and the appeal process.
Right, which does not change. So, okay, Delegate Kaufman, you have a quick question for us?
Yes, I do. I just wanted to ensure, and there's just a lot coming at me, so I wanted to make sure I understood it. I just want to ensure, given that this can be a transient population, and there's a big digital divide in this state, that I heard you correctly when you're trying to find the non-custodial parent to get them to pay. You are using the old-fashioned phone and texts and things like that. Did I hear you correctly?
Yes. And we also, depending on, sometimes the custodial parent will tell us that he, her, or them are transient. And that's when we look into the community partners to see where he is, or her, or them. Or if we find out the person could be on probation and parole, we reach out to those other partners so that we can get them engaged. And again, We may find out if there's incarcerated. We go to those other outside partners to find out where that non-custodial party is so we can provide services. So yes, sir.
And that's all during that investigation stage,
Yes,
correct? To
ma'am.
just
Yes.
Okay,
locate.
thank you.
You're
All right,
welcome.
Delegate Sample Hughes. Got
Thank
a
you, Madam
question?
Chair.
Sure.
Ms. Phillips Chester, thank you for the visual of the blue and the pink envelopes. I remember those from BGE years and years
Yes.
ago. But you know, honestly, on a serious note though, but do you have colored envelopes or it's all the same?
It's all the same. And we talked about that during this conversation, that we may need to enhance just similarly to a BG&E to say, hey,
Yes.
different color, whether it's the letter itself or the envelope itself.
Okay.
So it can kind of say, I need you to really pay attention to that. So thank you for that question, Delegate Sample Hughes. We were thinking about it. So we are on the same page of what we need to do to kind of enhance our letter process before we even have to get to the NBA process.
Yeah, I think it's necessary. We're visual learners, and we also know what colors come in the mail on many different subjects. But anyway, I think this might be one worth noting and looking into. My second question to you: all of this is very complex, and we're doing our due diligence to understand it amongst tons of other bills. Who from the department would come out into a community meeting to explain some of these new processes on the things that we have change here in this legislative session? Who would that be from the department? Come to the Eastern Shore specifically from me.
So that's a great question. So it would be the director of that particular jurisdiction. So you're in the Eastern Shore, that will be either the assistant director over the child support program or that director of the Department of Social Services or their designee. So each jurisdiction, they would have a leadership head that will be able to come to those community meetings or whatever community outreach event to educate customers. So it would be per jurisdiction, yes.
Okay, and last thing I'll say is that, while we're in session, we have constituents saying, well, what is this? What new changes that are coming up? And I was just trying to see if there was somebody specific from the state office is your outreach person, or do we go local with the specific questions and trying to get some guidance? So thank you so much.
You're welcome.
All right, so we are on an amendment. So I'm going to formally make a motion on the amendment. And the amendment is, again, to allow up to 120 days for DHS to conduct their investigations before actually filing non-compliance information with MVA, which means that they would need to follow certain factors that are included in the bill, and I described some of them earlier. For example, that if the child is living with their primarily at the obligor's home, if there's documented disability, if there's hardship, all those things would exclude someone from being a person that DHS would send over to MVA for a suspension. Okay. So do I need to clarify that anymore?
Nope. Second.
Okay, great. All right. Any questions on okay, so Delegate Bartlett's got a question on the amendment.
Yes, I have a question on the amendment. I just want to, because I didn't hear everything you just said.
Sure.
We're looking at page 4 for DHS's obligation.
Yes, that is
starting with
line 22 all the way over to 5, line 10 would be those things that would exclude someone from being put on the list that is sent to MVA in order to have their license suspended. So if there's some hardship that they've proven, disability that they've proven, the child primarily lives with them, they don't have the ability to pay, and they're making arrangements to do that, those kinds of things would exclude someone from having their name put on a list that is then sent to MVA to have their license suspended.
Thank you.
Sure. All right, so if we're ready to vote on the amendment, can I just see a hand raised to signify whether you are for the amendment? Okay, I think I see everybody. Great. All right, okay. And so on the bill with the amendment, is there, oh, I see Delegate Taylor and Simpson. Okay, Delegate Taylor, go ahead. I saw you first.
Actually, my hand was up because I was voting, but I do have a
Okay, go ahead.
just for clarification. So all those references to the courts would be changed, if still applicable, to the administration or to the department.
So in the bill, all of that would be removed, but currently they already have a process that they utilize that is similar, okay? So that, but we're taking out the sections that deal with that in this bill, but they are utilizing what they will be able to utilize what they already have, okay, which is what they call a contempt proceeding. When they get to a certain point, they recognize they're never going to get to this person. This person's never going to ever respond. Then they do that proceeding, and then the proper notices of service, et cetera, are sent out to the person. Okay, Delegate Simpson, did you have a question?
I didn't, but I do now. The system, like if you raise your hand, shows your hand raised. But so I thought we were changing the parts that we talked about the court. We were taking out the due process, and we were saying that the department would be doing those things.
That is correct. If you
Okay.
go to page
So
4,
what we talked about as far as the amendment is what we.
yes, if
Okay.
you go to page 4, it precisely at line 18 talks about the court will do the following things. We are changing that, okay? And I'm just pointing out conceptually wise that these are the things that they will have to do. We will have an amendment as soon as we can. Lauren will be working on that.
All right.
But for conceptual reasons, we're going to go ahead and take a vote so that we don't have to meet again.
That's great. I
On
just wanted to make sure that I
Okay.
was clear.
Yes.
Okay.
Okay. So can I get a motion on the bill itself with the amendment?
Favorable.
Second,
Okay, great. All right, so we're going to do a quick roll call vote on it. Delegate Bartlett,
yes.
Delegate Boucher, not here. Delegate
No.
Kaufman,
Yes.
Delegate Pastor,
Yes.
Delegate Sample Hughes,
Yes.
Delegate Simmons,
Yes.
Delegate Simpson,
Yes.
Delegate Taylor,
Yes.
Delegate Tomlinson, are you here? Yes, you're here. Yes, go ahead, Delegate Tomlinson.
Yes.
Okay, sorry. Delegate Valentine.
Yes.
Okay, and I'm a yes, and so we will move this bill also out of our subcommittee.
Delegate, you forgot me. You skipped over.
Oh, Delegate Stinnett. Oh my God, I totally did. Sorry. Delegate Stinnett.
Not a problem. Not a problem. Yes. Thank you.
Okay. I was looking at an old sheet when I.
Right. No worries. No worries.
All right. Thanks again. I think we are done. Anything else? Anybody want to talk about raise? Otherwise, I'd like a motion for adjournment.
So
So
moved, Madam
moved.
Chair.
All right.
Second.
Question.
We are adjourned. I'm sorry, did somebody have a question?
Yes. So do you happen to know? So I know on the floor we are told that for those of us who are on public safety, we'll start immediately following this
Yes.
one. So just
Yes,
hop onto that link.
you got it.
Okay.
All right.
All right.
Thank
Thanks.
you. Bye.
Thank you. Bye.